Oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please.
Good morning.
Case number 23-3054, United States of America versus Linwood Thorne appellants. Mr. Cohn for the appellant, Mr. Hahn for the appellate.
Mr. Cohn.
Thank you, Judge. In United States versus Glover, this court held that an application for a search warrant in the District of Columbia that expressly stated that it was seeking authority to search outside the district, in that case, it mentioned both Maryland and Virginia, was not valid because a District of Columbia magistrate judge only has jurisdiction to authorize searches in the District of Columbia. The lesson of Glover is definitely not what law enforcement did here, which is to file an application for a search warrant in which it didn't even mention any other state. It didn't even mention that it was going to search outside the District of Columbia. And what makes this even worse is that this isn't just an ordinary search. This was the installation of a cell site simulator, a device that collects the data of people making cell phone calls and in some case disrupts their telephone calls.
So, Mr. Cohn, I take it that your position is that there needs to be a finding, implicit or explicit, by the magistrate judge that there's probable cause to believe that at the time of issuance, the phone is in the District of Columbia. Is that your position? It's a probable cause standard?
If I understand your question to be the standard that the judge should be applying, no, that's not the heart of my argument. The heart of my argument is that the magistrate judge has to be given facts upon which he can judge under understanding.
And the facts that she's given have to amount to probable cause that the phone is in the district?
Well,
It's in your reply brief.
Yes, but it's important to note that for our purposes today, even under the reason to believe standard that the district judge applied here, there was no reason for the magistrate judge to believe that she was authorizing a search outside the District of Columbia. The very first sentence says, I'm authorizing a search in the District of Columbia.
Yes, Mr. Cohn, I understand that, and I want to hear that argument as well. But one of the premises is, what is the standard by which the magistrate needs to make that finding? And of course, in addition, there have to be facts in the affidavit to support that, et cetera. But I'm just trying to understand your position as to what is the standard by which the magistrate judge must determine that the phone at issue is in the District of Columbia. Is it probable cause? Is it reasonable suspicion? In the court below, I believe the position was there has to be absolute knowledge. My reading of your reply brief is that you now believe it's a probable cause standard. And I think that this is important in understanding your further arguments, but this is like a foundational question.
Judge, as respectful as I can be, in this particular case, it's not a foundational question because under any standard, the affidavit was so lacking that whatever.
The reason I ask you this, though, is because probable cause is not a particularly high standard. And it seems to me that the district court might have been confused about the probable cause standard because she seemed to think that there couldn't be probable cause that this phone is both in the district and in Maryland, because probable cause is less than 50%. We know that. And you can have probable cause, fair probability that the phone could be in the district, fair probability that it's in Maryland. It just seems to me that it's not that high of a standard. And there was information provided in the affidavit that the defendant has a home on Foote Street in the District of Columbia. It's a 202 area code. There's a search warrant executed there where it was confirmed that he lives there by his girlfriend, et cetera. So I don't see why that's not probable cause.
Okay. Now, I think I understand better your question, which is, let's say that there was probable cause in the affidavit that the defendant was, and his property, which the government wanted to search, was in the District of Columbia. Okay. The problem is, and it's a problem that happened in Glover and that happened in Kruger, and is that when the law enforcement seeks to search not in the District of Columbia, the fact that they may have established probable cause that the defendant is in the District of Columbia doesn't authorize a search outside the District of Columbia. And that's why the
Rule 41B does.
This all turns on whether it's a B1 or a B2 warrant, right?
Right.
You wouldn't dispute that if this was issued under B2, then the question would be, was there some basis reasonable to believe, whatever the standard, was the phone in DC at the time the warrant was issued? And if it was, obviously the phone could move. So if they learned that a week later it's in Maryland, this could have been a permissible application of a B2 warrant, right? Your argument hinges on it being a B1 warrant.
No, Your Honor. And I disagree with obviously the phone could move. That's something that needs to be in an affidavit. If you want a magistrate judge, this is a very serious device here. If a magistrate judge is going to authorize the use, law enforcement, of this cell site simulator, disrupting privacy of countless citizens, that it's not obvious if I sign off and say, oh yeah, he might be in the District of Columbia, or there's probable cause. That doesn't authorize a B2 search outside the district. The B2 is very clear. And
so my question was, if this was a B2 warrant, then this scenario would be permissible, correct? If it was properly issued as a B2 warrant,
yes,
it would authorize a search,
yes,
outside the district, including Maryland.
If to bring Judge Pan into the discussion here, if the application had said, we have probable cause to believe this cell phone has moved from the District of Columbia to Maryland, if that's the standard. But there's nothing in the affidavit that gives the magistrate judge the information.
I'm sorry, what you just said, are you asking for a standard where we would have to, law enforcement have to put in the affidavit that they have probable cause that it could move?
It's not in me, it's the rule that says, and it might move outside the district. It's not me, Judge Pan, it's the rule that says.
To issue a warrant. Okay, so it says a magistrate judge with authority in the district has authority to issue a warrant for a person or property outside the district if the person or property is located within the district when the warrant is issued, but might move or be moved outside the district before the warrant is executed.
Right.
So you're putting emphasis on the might move or be moved, but I thought that the focus of this appeal was whether it was located within the district when the warrant is issued.
No, Judge, and I'm sorry, and by the way, I'm putting emphasis not just on might move, but on the word if, which creates a condition.
If isn't in the.
Yeah, it is, Judge. The word
Where?
if, you just read it.
Where? I'm looking at the language right now. Is located within the district when the warrant is issued, but might move or be moved outside the district before the warrant is executed. Might move or be moved seems like a very low standard. I thought that we were focusing on whether the person or property is located within the district when the warrant is issued and what the standard is for that.
I'm looking at the rule. A magistrate judge with authority in the district has authority to issue a warrant for a person or property outside the district if the person or property is located within the district when the warrant is issued, but might move or be moved. In other words.
But if goes to whether the person or property is located within the district, which is what I thought this appeal was about.
No, Judge, this appeal is about the failure of the application to invoke B2 and to alert the magistrate judge to say, Judge, you're not just looking at whether this.
The warrant affidavit did invoke B2.
No, it did not, Judge. I understand the government makes a claim based on one sentence,
It's in
but
the
to
warrant
invoke
affidavit.
B2, just to repeat your words, one has to say, and this property might move or has moved outside the district. There's nothing in the affidavit about that. There's one passing sentence that says, oh yeah, and by the way, we have authority under B2. But that's not enough. The magistrate has to authorize a search outside the district. This rule doesn't.
So you haven't framed it this way, but I took a lot of your concerns to stem from Supreme Court precedent about the particularity of the place to be searched. That's not the way the circuits have addressed this question that you raise in B2. And your brief doesn't invoke that line of authority. But I understand your concern to be very much along the lines of what Justice Gorsuch has outlined in his concurring opinion. But the circuits have not adopted his approach.
Judge.
And here, as Judge Pan's questions imply, this case is focused on the first part of the obligation of the magistrate judge as to whether the defendant was in the District of Columbia at the time.
Judge,
Is that correct?
the reason I began with this court's Glover case is the concern in Glover, a binding precedent, is with jurisdiction. That's what the application has to tell the magistrate judge. We are invoking your jurisdiction to authorize a search outside the District of Columbia, which is, by the way, probably highly unusual, particularly with this kind of device.
So it's not enough if the government does refer to Rule 41 and at some point refers to B2?
That's right, Judge. It's not enough. An affidavit has to give facts.
Authority for that.
The opinion that's going to come down in this case.
Well, that's my point. This is a question of first impression.
Judge, I'm just
We are looking for some guidance here.
Well, the guidance is the rule I read to you. If the person or property is located within the district when the warrant is issued, but might move or be moved outside the district before the warrant is executed. That's the language from the rule. That's what law enforcement has to respect. And by the way, the language I just read, might move, is not, as I said earlier, in the affidavit.
So can I just try to make sure I understand the argument? So you're saying, which makes a lot of sense, when you read the rule, there's two requirements: was in the district and might move. And I think some of the underlying some of these questions is that in the briefing, it seems at least some of us read you to be focused on one. And we didn't see an argument that the application needed facts, but did not include them on the second requirement. So I think in your rebuttal, it would be helpful if you could point us to where in your opening brief you made this argument, because you absolutely made the argument that there's not enough facts, that the phone was in DC, the contacts from counsel came from Baltimore, but I don't think there was an argument that the application needed to say a cell phone might move.
Judge, the argument is in the brief.
And it would be very helpful if you showed us where.
Right now?
In rebuttal. That's just why I'm flagging.
Oh, in rebuttal. Okay,
Yes.
thank you. Okay.
One last thing. Why doesn't the good faith exception sort of resolve this whole case?
The Glover addressed that point, okay? And I tried to make that point in the very first sentences of this argument. Glover did not apply the good faith exception, said it did not apply. We're dealing, the comparison I like to make here is, let's imagine a prosecutor walks into federal court and it turns out there's a geographical jurisdiction fatal flaw. And the judge says, I'm really sorry, Mr. Prosecutor, we're going to have to dismiss your indictment here because there's a geographic jurisdictional flaw. And the prosecutor said, well, I in good faith believe that actually you had jurisdiction. The judge would politely tell the prosecutors, I'm really sorry, I like your good faith, but that's irrelevant to a
That's not
jurisdiction.
how the good faith exception works, does it? The good faith exception allows law enforcement to rely on a warrant that's issued by a judge.
Right, but the judge here, just to be clear, then to answer your question, let's say it does apply. I think it's odd to apply it in jurisdictional situations because there's no jurisdiction. It's what, but let's say that good
But
faith.
what about Magruder? Didn't we apply that in a jurisdictional situation?
Different case, different side, didn't even mention Glover, but okay.
But it's jurisdictional and it.
I understand.
Good faith exception.
Judge,
applied.
but Glover remains good law. But let's say that we want to look at the good faith here. Where in the affidavit does law enforcement tell the judge, we're going searching outside the district? Where does the magistrate judge say, I'm going to authorize a search outside the district? Nowhere. There's no facts about Maryland or anything like that, or any other
If
state.
under the good faith exception, if something's missing from the affidavit, it's taken outside of the good faith exception only if law enforcement exhibits deliberate, reckless, or grossly negligent disregard for Fourth Amendment rights.
Or it's facially deficient, which, by the way, is what the point that's made in the brief. And here it is blatantly deficient.
Okay, I understand your argument. Do you have any other questions?
Yeah, thank you.
Questions? All right, thank you. We'll give
Thank
you
you.
2 minutes for rebuttal.
Thank you. It's a little shorter.
Please proceed when you're ready.
Thank you, Your Honor. And good morning. May it please the court, Brian Hahn for Appellee, the United States. The district court in this case did not properly denied Thorne's motion to suppress for 2 reasons. First, because there was venue for the warrant in the District of Columbia. And second, because even if there was not, law enforcement relied on the warrant issuance in good faith when executing the search. As to the first issue, I think in terms of whether or not there was venue in the District of Columbia, I think, Judge Pan, you've said in the warrant affidavit, there was information that Thorne lived in the district, and he had a 202, or his new phone number was had a 202 area code. And when law enforcement officers went and executed a warrant at that location, his girlfriend confirmed that he had lived there. So I think there's certainly reason to believe that
What do you
Thorne.
think is the right standard? Do you think it's reason to believe that the phone is in the district at the time of issuance or probable cause? I see that in your brief, you kind of hedged your bets.
So I think that the correct standard is reason to believe. I think that's for a couple of reasons. First of all, because the standard is obviously not absolute knowledge. If that were the case, Rule 41 would violate, since probable cause is what's needed for a warrant. If you needed absolute knowledge something was there,
But
then
Judge
you.
Pan suggested that probable cause didn't have that highest standard.
That's fair. And probable cause does not have that highest standard. I think that the government does.
Absolute knowledge.
Correct. That probable cause is not that highest standard. But I think there's a couple of instances in the case law, in the Fourth Amendment jurisprudence, that suggest that when you're looking for a person or evidence related to an arrest, so here there's an arrest warrant and the search warrant is looking for information to locate the person to arrest them, that a reason to believe standard applies there. So one of those instances, of course, is Peyton, where if you have an arrest warrant for a person, you can go into their home without an additional
But that might not be
warrant.
always the reason
Yeah.
you want to get this information. If it shouldn't be a standard that turns on what you just said, because you might want to get this phone for evidentiary purposes. Maybe the phone's not on the suspect. And I mean, it has to be a more general standard than that under Rule 41B. And it seems to me that probable cause is the standard that is commonly used in achieving or seeking warrants. And reasonable suspicion kind of comes out of nowhere. It's also not really clear to me why reason to believe is necessary, because probable cause is not as high a standard as the district court seemed to think it was. It seemed to be important to her analysis that she didn't think that you could have probable cause to believe the phone was both in the district and in Maryland. But in my view, that's probable cause accommodates that type of analysis because it's clearly less than 50%. And if you've got a fair probability it's in DC because his house is here and he's got a 202 number. And you can also have a fair probability to believe that's in Maryland because he's got an auto shop there and he's got a 301 number. I don't think that's preclusive. It seems like probable cause doesn't have the practical problems that the district court thought it would have. To me, the choice should be between preponderance, because it's a jurisdictional fact, which usually you have to prove by preponderance, or probable cause, which is the warrant standard. But preponderance might have the practical problems that the district court identified, which is you want this information so you can find where this person is. If we had preponderance, we wouldn't need the cell site simulator. So it just seems to me that the choices should be between preponderance and probable cause, and probable cause seems to be the one that avoids absurd results and is consistent with the sort of general warrant landscape.
So I think I agree with you that probable cause doesn't have all of the problems that the district court judge believed it did. I think that the analysis of probable cause in this case was incorrect, as you said. I do think that reason to believe has been used to authorize a search for evidence when law enforcement is conducting a Gantt search, for example, when you're arresting a Gantt search.
What's that?
So when someone is, of course, when someone is arrested, and you can search their car if they have been driving one for evidence of the crime that they're being arrested for, if there is reasonable articulable suspicion that you might find.
You call that what? A GANT?
GANT, yes, from Arizona v.
Let me
Gantt.
ask you to give me some guidance here as to what the department's position is. It's a question of first impression. And at least one of the affiants in the case from the law enforcement said he didn't even think we needed a warrant. They had evidence that this man had a lot of drugs at Foot Street. They got an arrest warrant. So tell me when the department is taking the position this 41B2 warrant is required.
I don't think I know the answer to that question, Your Honor. I'm not sure
Tell
that.
from the brief. All right, and that's of concern to me here, trying to understand where we are, because you cite a lot of cases from around the circuits, but you can read them and say, well, it's factually distinguishable, procedurally distinguishable. And I'm trying to understand in this area where once you get this cell site simulator warrant, the way you are defending it in this case gives carte blanche to law enforcement, no matter where the phone is. If you start hearing pings in Wyoming, you can ask the provider to give you more information. So I need to understand what the department's position is on that question, to the extent we have to decide in this case, because going to good faith says to me, well, there wasn't a Supreme Court decision saying you can't do this, and there wasn't a statute saying you can't do this, or a rule saying you can't do this. So don't we end up with saying, well, this officer has a good record in the department or in the FBI or whatever, other law enforcement agencies involved, and, it was an open question. So we're just going to use this simulator and take B2, as far as it will take us. I'm just not clear where the department is. And your brief says, well, even if we made all kinds of errors, harmless error,
So
that's where you end up, which is where I started, that you knew this man and you had witnesses that he was the one who possessed an enormous amount of illegal drugs.
Well, I think under the plain terms of 41B2, when venue is established, venue has to be established that the person or property to be seized is in the district at the time the warrant is issued. And that if it might move outside the district, then a warrant also authorizes a seizure of that item or person outside the district. And in this case, I think it's a vagary of how this kind of search works, because the search and the thing to be seized here is not even the phone itself. We're searching the phone for information from the phone that tells us where the phone's location is. And so I do think, in fact, that 41B2 authorizes a search for that phone anywhere if we get information that it is in another district, because phones are readily moved. And especially in this case where Thorne was a fugitive and was avoiding arrest by law enforcement.
Well, you say he's a fugitive. I mean, he's a fugitive in the sense that there's a sealed arrest warrant out for him, but any citizen is given to know that you can't possess unlawful drugs. All right.
Sure.
So I'm just wondering what the limits are here. And I don't see any.
So
Because your brief just says harmless error.
So I think harmless error is sort of a separate issue here, I think,
No, you go issue by issue by issue by issue. And you say, but, even if law enforcement was wrong, harmless error.
Let me think about this way. I think you mentioned the particularity requirement when engaging with my fellow counsel here. And I think that is actually one of the limits on execution of warrants outside districts.
Well, but I'm thinking of those particularity cases in terms of, the warrant says we're going to search 422 and they get to 422 and it's an alley. And so they go to 424 and they search. Good faith. They had a warrant, obviously not for the alley, it's for the house. Sort of. This is a very different situation. And the district court says, at least the way she's reading the rule, it didn't contemplate this type of investigatory activity. In other words, as I understand it, the law enforcement could have posted a number of people outside of the Foot Street address and also outside of the Baltimore address. But that's very, manpower intensive. Now you can just use his cell phone and you can find out where he is, where he's doing his drug sales, etc. So that's why, in my thinking, I thought, well, if that's all that's left to the Fourth Amendment, then do we want to be careful, very careful, at the initial authorization? Because we have here an officer who says he doesn't even think we need a warrant.
So I don't know why.
Difficult questions, I know. But I hope you came with the idea that we were probably going to ask this since it was a question of first impression.
It's fair enough, Your Honor. And I think that in terms of whether or not there's something left for the Fourth Amendment after this, certainly there is. Certainly in a case like Kruger, for example, that we cite from the 10th Circuit and that appellant cites. That's where there's a violation of the venue provision, but not of the Fourth Amendment particularity requirement. Because the warrant there describes particularly the place to be searched and the things to be seized.
In this case, that what was presented to the magistrate would have to stop and flip through and read all these attachments before she ever would see a reference to B2.
I agree with that, Your Honor. And I think that magistrate judges do, in fact, or at least should, if they're not just rubber stamping them, review all the attachments, the affidavit from public comment.
Should be more precise and help the magistrate who's busy and has a docket. And, can't look in the weeds when this is a critical part of the government's request.
I think I agree that the warrant affidavit in this case could have been better. I think that
Would you recommend that,
I would.
your law enforcement associates?
I certainly would. But I think if the question is what is required under 41B2, what is required under the Fourth Amendment, and then beyond that, even if it wasn't sufficient, whether or not they could rely on the magistrate judge's issuance of the warrant in good faith, those are sort of different questions. And I think that in this case, both there was venue in the district and that the law enforcement could rely on the warrant in good faith.
So, counsel, I have a few questions. And the first one is factual. So when you've described the facts, you've described facts showing that, a basis to believe that the phone was in DC when the warrant was issued. Counsel today is arguing that the application also needed to have, but didn't, facts establishing that the property might move outside of the district, which is a requirement of the rule. And I just want to give you a chance to directly answer that.
Appreciate that, Your Honor. I think two things. First, that the rule says that the property might move outside the District of Columbia. And I think that because it is a cell phone, because it is a movable piece of property, and that the fact that, in Riley versus California, the Supreme Court says cell phones nowadays, people carry them with them everywhere. And that's one of the reasons why we need a
So you
warrant.
think it's so self-evident that a mobile phone can move that it doesn't need to be in the application?
I think that's,
Wouldn't there still be good reasons to make law enforcement say that, and so we have some confidence that the magistrate is actually making that finding?
I think that because the rule says might, and I think Judge Pan referenced this, might's a very low standard. If something might move outside the district in between the time the warrant is executed and the warrant is issued. And so I think that just sort of the background knowledge that cell phones can move satisfies that might standard.
I understand that response. So the next question has to do with the standard. One oddity of using things like Gantt or the cases about reasonable suspicion to believe someone's in the house so you can enter with an arrest warrant is that this is a venue or a jurisdictional requirement. And it just at first blush seems odd to think that you would have a reason to believe or probable cause standard for a jurisdictional or venue requirement. It would be far more natural to think it is a preponderant standard. That's kind of how we typically answer those kinds of questions. So I guess one specific question would be, can you think of another venue or jurisdictional requirement that is not done by preponderance of the evidence?
That's a good question, Your Honor. I don't think I can off the top of my head.
It's still possible the Fourth Amendment context is different, but I think one of your main arguments against a preponderance standard would be the kind of burdens that Judge Pan was referring to. But how burdensome is that actually? So in this case, there were indications the phone was either in Maryland or in DC. So the burden would be to go and get 2 warrants. In practice, is that really an incredible burden?
So I think 2 things, Your Honor. I don't know that it's an incredible burden, but I want to make 2 points about this. First is that if the phone is sort of in equipoise 50% between DC and Maryland, then I think we couldn't get a warrant in either jurisdiction. And that's the practical problem that the district court judge was saying. But I think the second thing there is that it doesn't, even if it's not a reason to believe standard, I think in the Fourth Amendment context, it should be probable cause. And that's because to issue a warrant, what you need is probable cause as to the items to be seized and the places to be searched. And so if we needed something more than probable cause, that means that Rule 41 would be setting a higher floor than the Fourth Amendment would, because now we will need a preponderance of the evidence. We need to, by a preponderance of the evidence, know the location to be searched, whereas all the Fourth Amendment requires is probable cause. And so I think that Rule 41 should be read harmoniously, like in that sense, with the rest of the Fourth Amendment jurisprudence. I think we've had arguments about why reason to believe we think is an appropriate context, but at the very least, it should be probable cause and not a preponderance or something higher.
Do you have any precedents that import reason to believe into a warrant context? Sufficient and any kind of warrant?
I don't I don't think explicitly for the issuance of a warrant. I think the Fourth Amendment clearly says that the warrant should be issued on probable cause. But I think Rule 41 is not the Constitution, obviously. It is a
But if
venue
it's a
provision.
jurisdictional fact, it should be by a preponderance of the evidence. That's the default for a jurisdictional fact.
Fair enough, Your Honor.
I just don't see where reasonable suspicion comes from or reason to believe comes from in this context.
I think that's fair enough, Your Honor. I think that there are contexts where it exists. I don't know I don't have a case for you in specific where it's been applied to either the issuance of a warrant or a jurisdictional issue.
But it seems to me that your position is as long as the phone is located in the district by whatever standard at the time of issuance, then automatically it can be executed, or the cell-site similar can be executed outside of the district. Like, because you don't think that there needs to be any facts that state that it will be moved outside of the district. You're just saying if it's here, then phones are mobile. We don't have to add any additional facts. Any old time that it moves out of the district, that's okay.
I think that's right, Your Honor, because of the reason that phones are very mobile. I do think that even if there was a requirement that the phone might move, I think that at the very least, the affidavit includes information that the defendant was perhaps not strictly a fugitive in the sense that he had escaped custody, but was avoiding law enforcement and wasn't turning himself in. I think that reasonably would allow the magistrate to conclude, or at least to infer, that he might be moving jurisdictions and his phone might be moving with him.
Well, law enforcement clearly had information about his pattern of activity.
Correct.
But this was not shared in the affidavit.
And I would have advised him to put in the warrant affidavit. But again, I think the question here is not what is the best warrant affidavit that could have been written. It is, what does the Fourth Amendment require? What does Rule 41B2 require?
That's right. And so what you're saying, as I hear you, is if I have a cell phone with a 202 area code, and there's some information, I live in the District of Columbia and I've designated it as my principal residence, you can get a cell site simulator and trace me around the world.
I think, I don't know about around the world, Your Honor. I don't know if for the territorial
jurisdiction. United States. Okay. Yes. I'm just trying to understand. I was trying to think back to the founding. What would it be? You want my diary, where I've been, what I've been doing, and it's very comprehensive. And so what kind of burden does a government have in order to get my diary?
So I think that there's, because of the way the search takes place, because it's searching the phone and getting information from the phone, it's like the warrant is for the information in the diary. And so in order to go into your home or your business or something like that, we would need a warrant from that district to go into that place and get your diary. But let's say we have a warrant to obtain your diary. We believe that we have probable cause that it's in the District of Columbia, but then a law enforcement agent fortuitously is walking around in Oregon and they see you holding your diary on the street. I think that, at least in terms of the venue provision, the officer can seize your diary because there's a warrant where probable cause has been found that your diary is evidence of a crime. And we're not intruding on an additional private area that the Fourth Amendment protects, like a home or a business or some other like lockbox or effect that you have. We are in fact particularly seizing, I think so long as the officer like really knows both that the diary is the subject of a warrant, that it can be seized, and that it is in fact the diary that we're looking for. I think the law enforcement officer could in fact seize that. And keep in mind, Rule 41B2, I think the advisory committee note talks about a situation where there is something on a train and we're trying to seize that thing on the train. And the whole point of 41B2 is so that law enforcement doesn't have to get warrants from every district the train might be traveling to and sort of time it properly so they can intercept it at the right time to get it from a district that they've obtained a warrant from. They can obtain the warrant in the district the train currently is in and sort of hit it when it stops. If it doesn't have a stop until the next jurisdiction, perhaps, then they can hit that train and take that object once the train stops there. And so that's sort of the practical reason why 41B2 was added to the rule, and sort of dovetails with the 1990, I think, one of the advisory committee notes, which says that what we're trying to do with Rule 41 is make it administratively easier for law enforcement to get warrants because we want to encourage them to get warrants as opposed to rely on some sort of exception. And so
on the issue of the information about ties to Maryland, which are not included in the affidavit, it seems to me that those would only need to be included in the affidavit if they would negate the probable cause that the phone was in the district.
I think that's right.
In general, it would be relevant to whether or not the phone is in the district at the time of issuance or not.
Yeah.
That there are also ties to Maryland. But I think you would only have to include it in the affidavit if it would negate the probable cause, because it seems to me that there could be probable cause that the phone is in DC, and there also could be probable cause that the phone is in Maryland. And if the Maryland information doesn't negate the probable cause for DC, and you're just trying to seek this warrant in DC, it doesn't seem strictly necessary that you would include it. Maybe as a matter of best practices, you should, but I don't think it meets, it certainly doesn't meet the good faith standard that, it would be reckless or grossly negligent not to include it or deliberately misleading. And it just seems to me that although it would be good to include that, it doesn't seem strictly necessary under Rule 41B or just general probable cause principles.
I would agree with that, Your Honor. And I would also note there hasn't been a Frank's challenge on appeal in this case that for some reason the government didn't have probable cause or didn't, the affidavit didn't have probable cause, or that there wasn't some sort of.
So why shouldn't we just decide this case based on the good faith exception and just not get into all of these sticky issues about Rule 41B?
Sorry, why should or shouldn't?
Why shouldn't we just do this based on good faith exception?
So I think that the court could decide this case on the good faith exception. I think that there are a lot of issues that we've talked about for 16 minutes for me. And I think that regardless of whether or not what the standard is strictly as to establishing whether or not the property's in the district, at least in this case, law enforcement invoked Rule 41B2 explicitly in the warrant. There was this is a warrant for a cell phone that's highly movable. There's information that the defendant might be avoiding law enforcement, so may move jurisdictions. I think in that instance, this warrant was not so facially deficient that the good faith exception shouldn't apply. I would note appellant's citation to Glover. I think Glover is an apposite because Title III, which is what Glover is talking about, has an explicit textual remedy in the statute that says that no evidence obtained in violation of this chapter can be used as evidence. And that's not the case here. Rule 41 allows for people to file motions to suppress, but doesn't say that. I think that follows. It doesn't explicitly say that evidence should be excluded, and so that sort of follows normal Fourth Amendment jurisprudence insofar as the good faith exception does apply.
So could I push you back, and apologies for more questions? As to burden on law enforcement, in this case, as I've mentioned twice before, one of the law enforcement officers didn't think he needed any warrant, period.
Is that
yet? I can find it for you if you want it. If in this case, the government went not only to a DC magistrate, but to a Maryland magistrate and obtain search warrants from both. That suggests to me that given the information law enforcement had, burden is not the type of, I don't want to say excuse, but explanation for not going to a Maryland magistrate for a cell site simulator. That's all. I'm just trying to figure out what's left. I hear you talking and I hear your response to our questions. But in my mind, I'm trying to think, well, there is a Fourth Amendment. And so we have some statutes and rules that are based on them. But what's left in this electronic age? And I understand why drug dealers keep getting rid of cell phones, or they don't use, the principals don't use cell phones. And I was just trying to think, how is the diary different? So.
And I think, again, well,
If the diary, if law enforcement knew that I lived in DC and that I paid taxes in DC, I had a car registered in DC, and, I was a diary keeper, but they also knew I had a home in Maryland. All right? And I paid taxes there, etc. Can you still go into my home in Maryland to get this diary?
no, Your Honor.
Even though, and so how do we draw that distinction? Because I think the government is telling me we had to get search warrants from both jurisdictions. We couldn't just piggyback.
I think we've been saying for at least this type of search that you could get the warrant in DC and then execute it in Maryland. And I think the reason why we can't go into your Maryland home when we have gotten a warrant in DC is that we are invading your home in Maryland. That's a separate violation of the privacy that the Fourth Amendment is protecting, your right to be secure in
But
your
once you have
place.
my diary in DC, you get it while it's in DC, let's suppose. And maybe I have more than one. And you have an arrest warrant for me. You can knock on my door in Maryland and say, we have an arrest warrant. And there are cases where you can come in and arrest me.
That's right, Your Honor.
Yeah.
That's sort of a separate issue, I think.
Right.
In terms of when an arrest warrant authorizes entry into your home and when, and I think there's all sorts of case law that I don't have.
Isn't the distinction here that what you're asking for permission to search is you're trying to get at the location of a cell phone? You're asking for a warrant that allows you to take an investigative technique and apply it to find the location of a cell phone. And so that is different.
Of a defendant.
Correct, who's likely with his cell phone. But what you're looking for, this is a cell site simulator warrant. It allows you to use this investigative technique to figure out where the warrant is. And so I think that the analogy to diaries and homes is different because then you have probable cause that there's something in the diary or there's something in the home and you get a warrant to search for the content of the diary or the content of the home. But this is purely a locational warrant. Where is the phone? And we know that the phone is mobile. You can move that around. And so the venue provision of 41B just says a magistrate judge can issue a warrant for property that's located within the district when the warrant is issued, and you might move that property. And so under Rule 41B, in terms of just getting that limited information about the location of the phone, if you have whatever the standard is, I think it's probably probable cause to believe that the phone is in the district at the time that the magistrate judge is signing this warrant, then you can use that cell site simulator technology, even if it's outside of the district. But I think what distinguishes this case from the hypotheticals that you raised with the diary is that we're not talking about the contents of the phone. You would need a separate warrant to get into the contents of a phone. We're just talking strictly about where is the phone. And in order to get a warrant that allows you to figure out where the phone is, you just have to show probable cause so that the magistrate judge can issue it, that it's in the district at this time. And probable cause is just a fair probability. And if the person lives in the district and has a 202 number and recently was in the district, according to his girlfriend, that's fair probability that the phone was in the district at the time that the magistrate judge signed the warrant. Because this is really just about whether the magistrate judge has the authority to sign this, because the magistrate judge is confined to the District of Columbia. But then the contents, all that, I think that is actually a very separate and different issue.
I think that's right, Your Honor. I think that certainly in this case, we would have needed, if we wanted to, in fact, search the cell phone, we would have needed a separate warrant. And in fact, law enforcement agents did get a separate warrant to search the phone once it was seized from the defendant when he was arrested. So I agree that that is certainly one of the distinctions between the scenarios that sort of makes it a little bit confusing and sort of hard to square because of the technology that is involved in just obtaining locational data from the phone. It is hard to imagine a search that looks for locational data that can be executed anywhere, because mostly you're searching places, and places don't move around as often as phones do. But since we're searching,
ever move around?
Sometimes I think they do when I'm walking around. They seem to be in different places than I remember. But
If it's a car or a van, I guess they could be.
yeah,
Any questions, Judge?
as if
You, Judge Garcia?
if there are no further questions, thank you. We'd ask the court to inform.
Thank you, Your Honor. Judge Garcia, the answer to your question about the brief is page 15 of our initial brief, and then at page 20 of the reply brief. With respect, I would although, I'm going to read the sentences from the initial brief. Thus, subsection B1 authorizes a search for a person located within the district, while subsection B2 authorizes a warrant outside the district only if the person, quote, might move or be moved outside the district before the warrant is executed. Here, the documents submitted in support of the warrant did not state that Thorne might move outside the district before the warrant was executed. And the warrant issued by the magistrate judge did not authorize a search on this basis. Law enforcement's application for a search and seizure warrant requested a search of a person or property located in the District of Columbia. Part of the reason this might not have been that much of a focus at first is that the reference in the affidavit to B2 was not even mentioned by the district court in its lengthy opinion. It was only in the government's opposition brief that the government started to rely on this one passing sentence. And so in the reply, page 20, the reply brief explains why just referencing in part B2 does not suffice to establish, actually getting to good faith that the law enforcement was seeking a search outside the district. I would like to turn to the diary point because Judge Rogers, I think that's an immensely helpful way to look at this case. In closing argument, the prosecutor talked about the contents of the cell phone, mentioning, and this is discussed at length at page 42 and 43 of the
But
initial brief.
there was a separate warrant to get to the contents of the cell phone.
You know, I just heard that. I don't know if that's that. I don't know if that's in the briefs, and I need to double check that point. And I'm not sure it matters. In fact, I would say it doesn't matter. Once you have located the cell phone and arrested the defendant, you're going to be able to search. But Judge, I will research that point, but I don't think that alters the serious jurisdictional flaw in the cell site simulator search. Either the magistrate judge had authority to say that, to authorize it, or he did not. And Judge, I do understand what the district judge seemed to be saying, what the prosecutor was just saying, and what I hear some members of this court saying is that somehow once you have probable cause to believe a cell phone is located in the District of Columbia, you have to use Judge Rogers' apt term, carte blanche, you being the government, carte blanche to search anywhere outside the district, to set up that cell site simulator anywhere outside the district. That is, and why? Why? Because a cell phone, well, obviously it might move. That is a staggering proposition. I mean, maybe Congress would say that, but to say that the Rule 41B2 says it when it explicitly says if you want to go outside the district, you need to get authority to do that. And to pick up on the train example, which is in the legislative history, is if law enforcement believes the defendant is going to get on a train to go outside the district, say that in the affidavit. Say he's getting on a train
Thank you,
to.
Mr. Cohn, I think I understand your point. Thank
Okay.
you. Mr. Cohn, you were appointed by the court to represent the appellant, and we thank you for your assistance in this matter.
Okay, if there are no further questions.
Case is submitted. Thank you.
Case number 24-1346 et al. CenturyTel of Montana, Inc., a subsidiary of Lumen Technologies, Inc., petitioner versus National Labor Relations Board. Mr. Scully for the petitioner, Mr. Cantor for the respondent, Mr. Demery for the intervener.
Mr. Scully.
Thank you, Your Honor. May it please the court. On August 10th, 2021, business manager George Bland, whose union represents a small group of employees at the incumbent local exchange carrier in and around Kalispell, Montana, sent an information request to John Bemis, the local manager. The information request sought information about non-bargaining unit employees. It is undisputed that Mr. Bland did not say anything regarding why the non-unit information was relevant to his role as the representative. In fact, he testified that he had no reason to even suspect that non-unit employees were infringing on the jurisdiction of the employees he represented. It is undisputed that Mr. Bland said nothing about any contractual claim, any grievance, or any related issue. Mr. Bland said he just wanted to investigate. What you've seen in the briefing of this case is the government and the union's attempt to backfill and augment the simple interaction between Mr. Bland and Mr. Bemis. That effort began at the unfair labor practice trial in this case when counsel for the general counsel for the NLRB produced for the first time purported reasons for Mr. Bland's request. At the unfair labor practice hearing, it was first disclosed that the information request at issue in this case was a form request based on internal communications from sister local IBEW unions, not even authored by Mr. Bland. Then the NLRB counsel introduced some old settled grievances unrelated to the interaction between Mr. Bland and Mr. Bemis. He suggested that those might provide a basis for Mr. Bland's request for non-unit information. On cross-examination, Mr. Bland denied that any of these newly introduced elements formed the basis of his request. It is undisputed he did not reference these things at the time. He didn't claim even that he had a suspicion that National Techs were doing bargaining unit work. He denied, in fact, that he had such suspicion. When asked by the judge, he specifically denied hearing or seeing anything that would give rise to a reasonable suspicion that national technicians were performing bargaining unit work.
Can I ask you a question? And this is just might be that I'm not an expert on NLRB matters, but is it correct that we can decide this case based on at any point was there reasonable belief or that it was relevant? Because it seems to me that there are sort of three different moments in time that seem to be at issue or that are discussed in the briefs. And it seems that if, for example, we could just resolve this case based on a finding, could we not, that at the hearing, there was sufficient evidence of relevance, that there was a reasonable belief that there was relevance. And then we don't have to consider sort of the first point in time, which was the contact, or the second point of time, which was the phone call. I just want to understand, like, is it that we have a menu of options that if we find that there's relevance at any of those points in time, then that would be sufficient?
Judge Pan, I think that the answer to that question was certainly is no under the precedence of this court as well as the NLRB. Specifically, this court's decision in New York and Presbyterian Hospital, which looked at the request, the reasons proffered at the time of the request. And if you consider the facts in this case, there is no reason that Mr. Bemis would have known about these interactions.
But do we have to address that if we think that there's enough evidence at the time of the hearing? And I understand that there's a due process argument, but that seems to be forfeited.
Well, Your Honor, I think we do have to address it because that's the time when the violation allegedly occurred. So Mr. Bemis at that point is in a position where he will violate or not violate Section 885 of the National Labor Relations Act based on his response.
But correct me if I'm wrong, because again, I'm not an expert in NLRB matters. I thought that at the hearing, they were addressing this question as to whether or not at the time that the request was made, it was relevant. But at the hearing, they looked at additional evidence and a bunch of other stuff. And I understand you to be arguing it wouldn't be fair to bring in information that Bemis didn't even know about. But I think that there's precedent on point that says you're allowed to do that in an NLRB hearing, and you're not asking us to overturn that precedent, which is Connelton.
Right. I'm not asking you to overturn any precedent, Your Honor. I think I'm saying that the precedent does not say what the government and the union claim it says. What those cases concern is they concern whether or not the union must actually prove relevance, and that proof could be adduced at the unfair labor practice hearing. This case involves a rare situation that has never been seen before the NLRB, where the union agent did not articulate any kind of basis of relevance. When pushed, he repeatedly said, I just want to investigate whether or not this is occurring.
But correct. And so I think I would probably agree with that he didn't articulate it. But then it seems that Bemis made statements that indicated that he knew that this was relevant based on the fact that non-union workers were in the jurisdiction working. And so I think that it is unusual in that I think they are relying on Bemis's statement to say that it was relevant as opposed to just Bland's statement.
Well, I think, Your Honor, what happened in this case was that there was a conversation that occurred and there's a difference of opinion about what was said. It was clearly, it occurred after the request was made. So it couldn't have been a basis for Mr. Bland's request to begin with. And he didn't articulate it as a basis at any time thereafter.
But that's one interaction because it's the request and then the rejection. You have to look at the request and the rejection.
Well, the
rejection hadn't happened yet.
Correct. But the time the conversation occurred, and I would say that there's nothing remarkable about national technicians being in the state of Montana, which is all that Mr. Bemis affirmed in his conversation. That is throughout the system, and that has nothing to do.
And I understand that that's
Yes.
kind of disputed, and that's why I think it makes it trickier to sort of look at the facts at that point in time. And that's why I was asking, like, can we just affirm based on what happened at the hearing?
I don't think you can, and I don't think it's consistent with this court's precedent to do that.
How is it not?
Because in New York Presbyterian Hospital, this court said specifically that we consider the reasons proffered by the union at the time of the request, relying on General Electric. And in General Electric, the Seventh Circuit clearly said that you can't rely on the circumstances presented at trial. And I think that
I'm sorry,
is.
what was that case?
The General Electric case was the case upon which New York and Presbyterian Hospital relied. New York and Presbyterian Hospital is 649 Fifth Third 723.
So Presbyterian Hospital didn't, but, well, did it involve the actual scenario here, like in the Piggly Wiggly case? Try to minimize the number of times I have to say that, but where they really were trying to introduce evidence for the very first time, because it didn't seem to me that in Presbyterian Hospital, we actually confronted and rejected that issue. And it does seem that the board's cases are pretty clear that this is permitted in terms of introducing the evidence for the first time at a hearing.
If I may address that, Judge Garcia, the Piggly Wiggly, sorry to say that again, and Cannleton clearly dealt with a situation where there were some facts on the ground that related to the allegation of an alter ego status, that there was something that the employer did. They had and the double breasting cases that the government relies on, the union relies on, there are always circumstances where the employer has done something and that has given rise to an allegation or suspicion sufficient to put the employer on notice that this could connect to the bargaining obligation, which of course makes sense. This case, there was absolutely nothing that occurred. There was no additional, and that's not to concede the violation, but it's to say that there has to be something, or else we've lost the distinction between presumptively relevant information and non-union information, because we're saying that Mr. Bemis has to regard a request like that as presumptively relevant and can't say what's the basis for that request.
Even if the record shows that he was employed at the time these previous grievances were filed. In other words, you are not arguing that the owner of the company as an individual had to be aware of these previous grievances.
Well, Judge Rogers, I think that two things about the grievances. Number one, they were settled, and there's not supported by substantial evidence that there was any prior diversion of work. That is absolutely not supported by substantial evidence, but they were from a prior entity. So there was no recency as well. Those are 3 years old at least. There was nothing that would have put Mr. Bemis, and again, I had the good fortune of being trial counsel and getting to ask Mr. Bland, was there anything? Did you see anything? Any of your membership see it? The judge asked him. There was nothing that occurred. And that definitively distinguishes this case from other cases in which there are some facts upon which the bargaining agent relies to say, hey, we want to know more about that situation so that we can bargain.
Your view is Mr. Bland's testimony could only be properly interpreted as a fishing expedition?
That is what I would say, and that it destroys the distinction between, again, presumptively relevant, where bargaining employees have admittedly consented to the union getting information about them, about their whereabouts, about their job duties. The non-union employees have not exercised their Section 7 rights and impliedly authorized the union to ask for that information. And I think that that's what's lost in this conversation about Cannleton and other cases, is that there is this group of employees that haven't chosen the union as their representative, and their rights are being infringed upon by treating a request like this as presumptively relevant, which this court has instructed us not to do.
How are their rights being impinged upon when the statute authorizes requests for information?
Mhm.
And whether the request is valid, legitimate, or what? It's a completely different question. So there's no suggestion that Mr. Bemis was asking for something he was not authorized to ask for,
Well,
but simply that, as I understand your argument, he had no reason to be concerned. And yet, as you point out, these non-union employees have been around for a long time. We've got these previous grievances that were settled. I mean, I'm just trying to understand why Mr. Bland's inquiry has to be viewed as somehow, suspect, if I can best word I can come up with.
I can address that, Your Honor. I
Yeah.
think that the point is that the reason there is presumptive relevance is because a majority of employees have certified the union as its bargaining representative and thus empowered it to ask for information relevant to its duty to represent those employees. And there is no connection that the union agent has through that certification to the non-union employees. And in that sense, has to be a demonstration. There has to be, and all we're saying is there has to be an articulation of relevance. And there has to be evident facts and circumstances. And in this case, we have neither of those things. We have no facts on the ground.
Can you just focus on the call and
Yes.
proceed as if that was basically the only fact? So this is certainly not a slam dunk for the board, but I'll do my best to say what I think is going on and give you a chance to respond. So I think it basically comes down to whether the call would give someone is a basis to think there might be work diversion occurring. And from the company's perspective, when Bemis says there are national technicians working in your general geographic area, that's not suspicious at all, because you know, apparently, that they've been there for a long time and they do different kinds of work. But Bemis didn't say any of that to Bland. So from Bland's perspective, the situation is I represent a bargaining unit of this general type of technician. I just found out, it's news to me, that now there's these other technicians in our area. I ought to look into it. And again, not a slam dunk, but why is that not a reasonable view of the evidence?
Your Honor, because there are all manner of people in this, employed by this company, working all over the state of Montana, both in the incumbent local exchange carrier. There are managers, there are supervisors, there are people of all stripes who are working there. The fact that they're merely working in the geographic area gives no rise to no suspicion with respect to any infringement on the bargaining unit work. And I think that by identifying that, and I would also challenge the point that Mr. Bland was unaware on cross-examination, he acknowledged not only another IBEW Local 206, which is a separate jurisdiction as well. He indicated the previous employer, CenturyLink, had national technicians, and he acknowledged that in his cross-examination. So I don't think it's accurate to say that he didn't acknowledge that. But even if we accept that, there are these other employees, managers, supervisors outside the bargaining unit who are performing tasks in the geographic area, and without something to give rise to any kind of suspicion that that individual can articulate, it is simply improper under this court's precedent to impose the duty to provide information.
Thank you.
Do you have any other questions, Judge Roberts? Thank you.
Thank you
Give
very
you a
much.
minute for rebuttal.
Thank you.
May it please the court, Jared Cantor on behalf of the National Labor Relations Board. Your Honors, I want to make 2 points that I think will help. First, there seems to have been agreement that the controlling standard here is a liberal relevance type standard, which requires a mere probability of relevance. Second, essentially in plain English, the question here is, for the board's first analysis, did the union, and this is language coming from the New York Presbyterian, did the union explain why it was asking for this information? And when you look at how the court talked about this in US testing, you're looking at, did the employer have notice of why this was being asked for? Was it adequately informed? And respectfully, under the deferential substantial evidence standard, I would submit that the board's primary analysis might be the most straightforward to enforce the borders on.
What do you mean by primary analysis?
So that was the board's analysis that the union established relevance upon making its request. That analysis talks about or relies on the request itself. And then the board talks about Bemis's admission. That conversation is sort of independently establishing the relevance of that request. And as Your Honor, Judge Pan, I believe, talked about, the request is made and this phone call happens within hours, same day for certain. Bemis is not the one who refuses. He essentially just passes this along. It's not until September 1st, I believe, that you get, I want to make sure I'm accurate on that, September 1st, that Noble replies. She gives some information, she withholds others. That's where you essentially get the refusal to provide that information. And I think what's noticeable about both Bemis and Noble is Bemis clearly understands that he has a concern. What's going on here? He's not confused. He's asking, he says in his testimony, there was no grievance pending. So this sort of caught my attention. What's going on here? Noble, in her answer, September 1st, for the information she doesn't provide, her response is these national technicians are not in the unit and they're not performing bargaining unit work. So the company essentially is on notice that why is the union asking for this information? This would not be trying to think of.
Can I ask, I just want to understand as a threshold matter, what you think the rule is. Imagine a case where this union had no indication whatsoever that work diversion was occurring.
In its jurisdiction or anywhere.
In its jurisdiction, that would affect it. And they asked these questions. The company would not be required to respond, right? There needs to be some, maybe very minimal, but a basis to think that it's relevant to their union.
Well, I think, Your Honor, potentially, but the facts here obviously show these telecommunication council reports.
Well, you said potentially, right?
Potentially, because
I just want to, right. I think it has to be yes. You cannot, we heard that there was work diversion in Texas. Now, every single one of our locals is going to ask for information to find out if it's happening in their jurisdiction.
Well, it was 3 reports, Your Honor.
No, I'm not talking about the facts of the case. I'm saying you would agree with the general principle you cannot embark on a fishing expedition just because if you did uncover something, it would be relevant to enforcing your CBA. There needs to be some like minimal basis to be asking the question.
Yes, Your Honor. I mean, essentially, it's thinking about hypotheticals and the going hand in hand. A union could submit.
Yeah, sorry, I don't want to go down that path. So then let's go directly to the call.
Okay.
The company's argument is there's just nothing suspicious about saying technicians are working in this area of Montana. There's all kinds of technicians and other types of employees that have always been working there. What's the cause for suspicion? And that does strike me as the key question in the case. And could you just explain why?
Sure, Your Honor. As Bland testifies that he had been in one form or another a union official for 13 years, he had never heard this term national technicians until the Telecommunications Council put it on his radar. Then during this phone call, he asked Bemis, are there any national technicians working in my jurisdiction? And the company doesn't really challenge the board's credibility resolution here, or at least acknowledge the standard. Bemis then says a couple of techs have been in your jurisdiction. He says a few times, but not many. And that's essentially what he says is the extent of his knowledge. But I think
the board was finding that he admitted there. It wasn't that in the jurisdiction, they were actually doing union work, right? That he meant, or the board thinks he meant, at least they're working in your geographic area.
Yes, because I think if his admission was taken as that kind of admission, the analysis would be quite different. And you could have gone straight to, pass go get your $200. There's a violation of the CBA. And I think that's another important thing to remember in this area is that this is supposed to be an investigatory process. This is very, very early on. When we talk about Acme talking about this is a discovery type standard. You're not necessarily going to get evidence with your first request that's going to be admitted at a trial. You're getting evidence that might lead you to further evidence.
So what's very odd to me is that we're trying to determine if the union has demonstrated a reasonable belief supported by objective evidence that the information is relevant, but we're relying on Bemis's response to the union request. And that's strange to me. And that's why it seems to me if we have the option of doing so, the most I guess, efficient and strong way to resolve this case would be to go straight to the hearing and rely on all the evidence that was submitted there, because there we also have evidence about what caused Bland to make this request, which is that, you know, there was information that this type of unauthorized work was happening in other jurisdictions with these national tax. Maybe it's happening in our jurisdiction, which gives him a reason to believe maybe there's a problem here. Why wouldn't we just rely on the hearing evidence if we're allowed to do that?
I think that is another.
Because there's more evidence at that point.
Yes, Your Honor, there certainly is more evidence. And, you know, with regards to that standard about union need only demonstrate a reasonable belief supported by objective evidence, that's where you have to sort of understand how these things play out. That is the general counsel's burden in front of the board as part of litigating the case. The union doesn't litigate the case. They would have.
I understand that.
So that quote, if you look at where that comes from, it comes from the board's Disneyland case. Really what we're talking about there is that's what the general counsel had to show that the union had.
But in making that showing, they're relying not just on what the union said or did, they're relying on the response to the union. If they're going to rely on Bemis's statement, Bemis doesn't work for the union. Like that's what's
Correct.
strange to me, that you can rely on what Bemis said to establish what the union believed.
Well, it's not, it just establishes the question of whether it goes to the relevance, and it goes to, I think that other thing I talked about was the company on notice of what they were asking for. I mean, if you think about a case where the request for information is this, please provide, CenturyTel, please provide us the names of all employees in the state of Montana, all of your employees in the state of Montana, their position and their salary information that aren't in the union.
Right.
The employer is going to say, what does this go to?
Yeah.
You can imagine another hypothetical. The union writes a treatise explaining in detail why it wants certain information, but it wants to know the address of the CEO's vacation homes. They've clearly communicated why they want that information, but the relevance probably is not going to be there. You sort of need that handoff. You need an explanation that puts the employer on notice, going back to US testing. Is the employer on notice? Was it adequately informed about why the union needs this information? And the request is extremely detailed, and the cover email.
So it's just interesting to me, like why it is that there's sort of these choices of looking at what was relevant at different points in time, when it must be the case that in every case you'll have the most evidence at the hearing, because you have this rule that additional new evidence can be presented at the hearing. It was done in this case. Why should we even look at the earlier points if we're allowed to look at the hearing evidence, which is the most evidence? It's always going to be the most evidence, is it not?
It might not be, Your Honor, because a union, again, looking at the facts of this case, in their opening letter, requesting the information, they could have said, we're submitting this because we've heard through the Telecommunications Council that in 3 other locals,
But
these
that's
national.
in the hearing too. You're not going to not admit.
Well, that wouldn't be new evidence. It would have been part of.
I'm not saying relying only on new evidence. I'm saying just rely on all the evidence that you have
all
at the
the evidence.
hearing.
Yes.
You can do that in every case. I don't know why you would
Yes.
ever go earlier, because you have less evidence earlier.
Well, I guess, Your Honor, it would only be the board's analysis would only be at the earlier time. Even though that evidence would have come in at the hearing, the board would be looking at, did the union explain relevance upon making its request? That's always sort of
Well,
the
they don't have
default.
to explain it apparently, because you can have new evidence that wasn't even explained. Because in this case, they relied on evidence that Bland did not communicate to Bemis. That there's new evidence.
Well, that evidence comes in to show whether the union's relevance was based on a reasonable belief supported by objective evidence.
Isn't that the whole question we're dealing with here?
Well, yes. But sometimes that evidence,
Then I'm
the
not
union might have.
I'm not understanding you, because I'm asking you, if you're trying to answer this question that we're trying to answer in this case,
Yes.
why would you ever not just go to the hearing evidence where you have all the evidence plus new evidence? You have the most evidence at that stage in the process. So I don't know why there are all these arguments about these prior points in time.
Your Honor, I think it's only in this case because other evidence came out at the hearing. But in a case where no other evidence, again, those cases might not have been litigated, but in other cases
Well,
where
it's
all
also
the,
because the dissenting board member and
Exactly.
common sense would seem to
Right.
suggest that it's a pretty odd rule to let you ambush the company with new evidence at the hearing, right? So
well,
can I just
And
ask a
this court-
clarifying?
This court has said we must address the dissenting position. The board must address the dissenting position when it's not frivolous or something like that.
well,
So the board did here. So I thought that's why you were focusing on pre-hearing evidence.
well, I get, no, Your Honor. And to Judge Garcia's point, what the Hertz standard is just when you're explaining the relevance of the information, you need to give some facts. That's what the Third Circuit said in Hertz, and it talks about this in its Kreuzer opinion. But even under Hertz, there's the apparent relevance. I don't want to call it an exception, but Hertz is not just a
Put
set
the Third
standard.
Circuit aside. This was my clarifying question. I just want to
Right.
understand your position. Assume under board precedent that he had just asked these questions. He never gave any basis whatsoever.
Mhm.
It all comes out at the hearing.
Yes.
Do you think that is permissible under the board's cases?
Yes, that is permissible under the
Okay.
board's cases. Yes.
That's what I understood.
Yes.
Could you briefly try to defend that rule? I know the first thing you would say is that it's forfeited, but if you put that aside, why in the world would we have a rule that encourages or even allows unions to hold back evidence and bring it up for the first time in a hearing?
Well, Your Honor, so to my knowledge, the board has, there's no, if the concern is due process, I'm not aware of because
I'd
that's
also
the
be a
argument.
statutory concern. Why are we, it ought to be an exchange of information. We could have not had this entire case if Bland had just shared the information he had, and maybe the company would have agreed without going through a hearing and being labeled a NLRA violator. It just seems like a very odd way to run the railroad.
Well, Your Honor, there might be a best practice, but reasons that come to mind why a union might. On the one hand, it could be that they might be getting information from an inside source. A supervisor, a manager is leaking information to them and they don't want to reveal that. Also because, the standards here are there's presumptively relevant information and then there's just everything else. It's not a dichotomy of presumptively relevant and not presumptively relevant, that there's this big hurdle. So the standard is low, which is why there's never been a requirement that in explaining relevance, you support it with facts. Again, the Third Circuit took a different view in its Hertz decision. Another reason could be, again, I'm speculating, but to answer Your Honor's question, your information request, you put some facts in there. The employer is now going to want to start arguing with your facts. And the whole point of this is to be a mostly seamless, low bar to get information as part of your investigation. Because as was acknowledged, the union has a duty here to administer and police its bargaining agreements. And that duty is not theoretical. That duty is to its members. And one of its most important duties is to make sure that the employer is not siphoning off work in whole scale or just around the edges.
More questions?
I was just trying to listen to what he said.
Do you have any more questions?
I don't.
If there are no further questions, the board rests on its brief. Thank you, Your
Very
Honors.
Mr. Demery.
Good morning, Your Honors. May it please the court. I'm Jacob Demery. I represent the union. I agree with everything counsel for the board said, but I'd like to emphasize that this is factually and legally a very simple case. The key question is whether the union first articulated a basis for its request, and second, whether it had any evidence to back that up. Here, on page 344 of the record, the union articulated the basis for its request. It said that it was requesting information regarding national techs in the union's jurisdiction. That's in the initial email to CenturyTel conveying the request. Now, there was sufficient evidence at the time backing that request up. That's the telecommunications emails that, as we were discussing, were introduced at the hearing. But the union had those emails before it made the request. Those emails showed that in other jurisdictions, National Techs may have been performing unit work. In any event, addressing some of Judge Pan's questions on why we would consider evidence after or introduced before the hearing or evidence that wasn't, just introduced at the hearing. During that conversation between the union and CenturyTel on August 10th, CenturyTel, as it admits on its brief in page 19, it conceded that National Techs were in the area. That's all that's required to establish relevance. And that's all that's required to require CenturyTel to provide the information in this case.
You mean geographically in the area versus I understand there's some confusion about jurisdiction, like geographical or doing the work, but you think just that would be sufficient, just saying they're in the area geographically?
Yes, I do, Your Honor. And just to clarify for jurisdiction, from the union standpoint, jurisdiction can either be geographical or it can mean scope of work in terms of union class differences. And so the only meaning that actually makes sense here is geographical, though of course it's a distinction without a difference here, because even if we assume area, the broad definition that CenturyTel describes, area means work that could be potentially occurring within the collective bargaining agreement, could be potentially unit work.
So if they're geographically there, does that implicate your collective bargaining agreement? I thought it had to be actually doing the work.
So let me answer that question. Yes. So if they're they would have to be performing unit work to violate the collective bargaining agreement. But here, the standard is not whether they're actually violating the agreements, whether they may be, there's a potential violation of the collective bargaining
What's the
agreement.
cause for suspicion?
So the
Just that their name has technician in it or something else?
So Judge Garcia, the cause for suspicion is that there are these employees who perform work that overlaps with the union's work in the area. And so there's potential here that there is work diversion.
But what's the basis for saying you thought their work overlapped?
So that basis is in the Telecommunications Council emails where we have reports from other local unions explaining that.
So unless if we don't look at the hearing evidence, I'm not saying that we won't. Was there a basis without that evidence, without the hearing only evidence?
Yes, Your Honor, because if we look to the initial email to CenturyTel, it says requesting information about work that's occurring in its jurisdiction to investigate violations or potential violations of the collective bargaining agreement. And so in the conversation about that request to say that, yes, National Techs are in the area, that is
that
enough.
first email, when it uses the word jurisdiction, does that mean geographical jurisdiction or does it mean doing the work that's encompassed by the collective bargaining agreement?
Your Honor, as I understand the email plus the text of the information request together, that means work in would be violating the collective bargaining agreement. Again, it's not necessary to understand what jurisdiction means here. We can take the understanding that's area. But in the context of a request for information to understand if there are potential violations of the collective bargaining agreement, that shows that conversation is potential evidence of a possible violation. I'd like to emphasize that actually, I see that my time's run. So if the court has any other questions, I'd be happy to answer them. But if not, I'd like to thank the court
I'd
for its
like to
time.
hear what you were about to say.
Sure. I just very quickly touch on relevance. The standard here is whether there's some evidence showing a possible violation, not that there's an actual violation. So if in that conversation, there was an admission of actual unit work diversion, if jurisdiction had to mean unit work and there was no admission of that, yes.
So here's what I just wanted to ask you. You heard counsel for petitioner basically saying a new employer, although he's been there 3 years, he says, I thought it was only 2. In any event, no reason to suspect. And what I wanted to understand about this case is the nature of the work being done by the employees who are represented by the union, such that it's not a question of what's happening elsewhere in other jurisdictions, but there is some potential overlap. Or is it simply that the nature of the work that the employer wants accomplished includes both?
So if I understand your question correctly, Judge Rogers, the work that the union technicians perform is both in the central office in Kalispell, Montana,
Right.
all the way into customers' offices. So they'll work with the network.
Right.
as it seems from the record, and again, that part of the reason for this sort of request is that we don't know what all these national techs are doing. It seems that the national techs are also performing work in customers' offices. And so if they're both doing that work, that those national techs would be performing unit work. And that would be a violation of the collective
So
bargaining.
who's in the building where you need a key?
So the building, that's referring to the central office in Kalispell. So there are definitely union technicians in that building, but it's not necessary that there are national techs in that building.
But there may be.
There may be, yes, certainly, but
And they may, I'm just trying to understand is the complexity of what's going on such that it may not always be clear who's a union employee, clear in the sense of somebody from the outside. A union employee versus a non-union employee.
I
So
think
that
that,
it has
yes,
to be monitored.
I think that's certainly true, Your Honor. From the customer's perspective, someone comes in wearing a CenturyTel uniform or a Lumen uniform, it would not be clear who the union, if they're a unit employee or not. And from the union's perspective, working in the field, understanding and monitoring whether there are actually non-unit employees performing that unit work in the customer's premises is incredibly important. And so that underlies why this request is important and underlies why it's necessary to have this information to determine whether there should be a potential grievance or unfair labor practice charge.
Thank you.
Thank you very much.
Thank you, Your Honor.
Mr. Scully, we'll give you 1 minute for rebuttal.
Thank you, Your Honor. I just want to address a couple of points. The first is your question, Judge Pan, about why don't we just rely on the evidence at the trial? And the reason we don't is because we have a system, a regulatory scheme under the National Labor Relations Act where the union is the bargaining agent. The government is not the bargaining agent. The government doesn't get to augment the union's information request because it doesn't get to affect the bilateral duty to bargain in good faith. And in this case, what effectively the government tried to do is to backfill the union's articulated reason for the information, which wasn't there. I think what the record discloses is that Mr. Bland simply did what everyone else was doing, and he sent this information request along. And to Judge Rogers' point, when specifically asked about those very facts, have you seen anything? Do any of your members see anything? Has anyone seen? There's no record evidence of national technicians doing anything within the jurisdiction of the union. And we'd ask, based on our briefing, that the review be granted and the orders be denied enforcement.
Can I ask one very specific question? I'll try to be brief. It concerns the subpoena issue. I just want to make sure I understand the nature of the prejudice. The confusion I have is that the subpoena seems to ask for the documents to be produced at 9 a.m. the day of the hearing. And the complaint is that they were produced during the hearing. And I just wanted to, perhaps there is some prejudice to that intervening hours, but is that the nature of the prejudice or am I misunderstanding?
Well, the rule that the NLRB applies is a sanction against introduction of evidence that is not produced pursuant to the subpoena, which was what I was attempting to invoke to bar that and say that those documents are what you now purport are the articulation of relevance. Why weren't they produced in response to the subpoena?
Okay.
And so I was asking the judge to exclude the evidence.
I see. Okay.
Thank you very much.
Thank you very much.
Case is submitted.
This is honors before the States is under 17 at 1:30 a.m.